right. So the segues so nicely. Thank you, Teresa.
So I talked too long, so go to Michael first, okay? I used up some of his time.
No. This is good. I think we actually have a little bit of buffer built in, and this is meant to be actually fairly organic. So I'm not concerned at all. No, that was, I think, a great segue into the next session, which is really touching on some of the strategic direction that I talked about earlier today, but also that we talked about at our last plenary in November, is that we want to equip law associations to do more work to influence decision makers that impact our sector, whether those are those decision makers of the Law Society or the Ministry of the Attorney General or federal decision makers in the justice sector. And so that's what this session is about. We've got two exceptional panelists here who I will perhaps give them an opportunity to just briefly introduce themselves, and then we'll get into it. So maybe I will start with Mike.
Sure. I'll give Teresa a break to get her breath. Catch her breath. My name is Mike Wilson. I'm a litigator at Goodman's. Where I practiced law for 8 or 9 years, with a brief reprieve for about a year and a half, 4 years ago, where I worked for the Attorney General, first Minister Mulroney, then Minister Downey, from mid-2018 into the start of 2020, before returning to practice. And it's from that perspective that I'll try to give you some insight today on how to get the attention of government on issues that concern you.
Thanks so much. I don't know if you want to add anything. I think we all know who you are.
I have to give a disclaimer. So I am a sexual violence prosecutor with the Ministry of the Attorney General. So I'm not talking about how to influence the Attorney General. I can't be giving tips on how to influence my boss. So I'm here from my perspective as the former treasurer, as you know. So with that disclaimer, I think that's all you need to know.
This panel is how to make friends and influence people. So,
He's doing the Attorney General part,
I'll do the
though.
Attorney General part.
And don't be intimidated that it's being recorded and broadcast on the internet.
Just means I can't curse.
We don't have any rules about that. Actually, I was going to start with Teresa, just jumping off from your presentation. You talked a bit about the structure of convocation, gave us that great overview. Can you tell us a little bit, just to orient us a little bit further, what's the function of the treasurer within convocation, within the Law Society, and how does that role? What is the role within that structure?
So the treasurer, as I said, is the head of the Law Society, the president, and responsible for setting and managing convocation. Convocation being essentially our board meeting, our decision-making body. And we do, so the treasurer, one of the first things that Treasurer Horvat will do now that there's a new bench is she'll appoint committees. She'll appoint committee chairs, vice chairs of committees, and who's going to be on those committees. Those are really important appointments because who's on the committee shapes the policy work, because that's where the policy work is done, through the committee structure. So, and I showed you all the committees. They're all online as well. And so that's the treasurer's role, is sort of managing all that. The treasurer also works very closely with the chief executive officer, Diana Miles, who you're going to hear from this afternoon. And Diana then is in charge of the senior management executive. We have two here, Priya and Sheena. And so they're sort of the heart and soul of the Law Society. They're the stability. The bench can change every 4 years, but they're the ones who are there and provide support to the benchers, the policy work, all that. So that's just sort of an overview of how it works in terms of, so the senior management executive is really, really important. So I'm thrilled, actually, that you have 2 members here. Maybe we can lobby to get more from next time. But it's and really, really important. And to have Priya from PD&C is important. And also Sheena, because if you want anything done, you go to Sheena, okay? That's my advice to you. If the only thing you remember to take away is you want something, go to Sheena, because she's going to do whatever she can do in terms of her role as with external relations and the stakeholders to get the job done. So it's really important to continue to foster that.
The same applies at MAG.
Also go to Sheena. that, you know, and my next question was actually about the senior staff of the law study, and so I think we've covered that. So maybe sort of pivoting to the provincial world, and Mike can tell us a bit about the function of the chief of staff within the Attorney General's office, you know, vis-a-vis the minister and the ministry. How does that, how do you juggle that?
Yeah, so I guess the starting point is to recognize that there's two sort of senior leadership roles in the ministry, the Attorney General or the minister, and what any other ministry we call the Deputy Minister, and at MAG we call the Deputy Attorney General. And so those two people are jointly to be steering the ship. MAG has 4,000 some odd employees, or at least it did when I was there. I don't know if it's higher or lower now, but, and those people almost entirely report up through various levels, associate deputy ministers into the deputy minister. And the minister, or the Attorney General, is supported by his own staff, ranges between 10 and 15 people that assist him in liaising with the department, giving instruction to the department with their team, and helping formulate decisions. And the chief of staff leads that team. And so essentially plays three roles. One, supervise and manage that team and their different communications functions, policy, advice functions. Liaise with the department on behalf of the minister, on behalf of the Attorney General, so convey instructions, convey requests for information, and serve as a sounding board for the attorney himself, or herself, so that they can, you know, when they're deliberating on decisions that have to be taken, other than criminal prosecution decisions, obviously, speaking with them about that decision-making process and the various options that are before them.
So can you tell us a bit about, you know, we people read news from the justice sector, we see various parts of the legislature reflected in that news. What is the connection then between the role that you would play, the minister's office would play, and the Standing Committee on Justice Policy of the legislature versus the Premier's office? And what's that symbiosis between those different bodies?
So the main conduit to the Standing Committee on Justice Policy is through the parliamentary assistant to the minister. So there's always a member of provincial parliament that's designated to be the minister's parliamentary assistant, or the Attorney General's parliamentary assistant. And that person's a member of the Standing Committee and leads the work on that committee from the minister's perspective. The members of that committee obviously have, as any member of the legislature, but they're typically the people that are more interested in the justice policy issues, have the ability to go up and speak to the minister at any time, either in the House, no matter what side of the legislature they're on, in terms of party. The other thing to keep in mind is once we introduce legislation, we have to work with members of those committees to analyze and tweak and refine. And if it's government legislation, obviously once it's introduced, it's not set in stone, but there's obviously a view of the direction that should be taken. But those members of that committee have the ability to influence kind of around the edges how things should take shape. You don't usually see massive change at committee, but you see refinement. So some idea that maybe was good in theory that didn't really get worked out gets introduced into the bill at first stage. Members of the Justice Committee are good to sort of smooth down the edges.
So maybe just jumping off that a bit, periodically there's legislation that comes forward and we see opportunities for organizations or individuals to make, I don't know the word, deputations to committee. Is that a useful exercise, or should there be background work that's going on in concert with that?
I would, if you want to change what the legislation says, I wouldn't try to do it just through a deputation. I think deputations are helpful for groups to undertake because it gives your organization profile. So when future decisions are getting made, you know, when decisions get made, you'll look and say, okay, who are the groups that are going to care about this? And so if you've been at the table before making submissions, then you know you're a group that's going to care about it. So you want to sort of understand what that group thinks. So making deputations as, you know, FOLA, it's a regional issue, one of the local law associations, are helpful. You do have to be obviously careful because you're then on the public record saying your views on government policy, and if a minister owns it and sees you slamming it, you know, they might not care what you say in the future.
I can't imagine doing anything like that.
No, so it's sort of, and it's almost like the constructive criticism feedback you give when you have to give a performance review. Like you try to find something good, you know. Yeah, I like that you spelled all the words correctly in the first section, and but section 2 is really a problem for me. Or whatever the constructive criticism.
The part that was in crayon was hard. Yeah, okay. So the next question is kind of for both panelists, so maybe I'll go back to Teresa first. And the question is, how can stakeholders, like county and district law associations, but others, how can they get the ear of the respective heads of these? So we're talking about the Ministry of the Attorney General and the Law Society. What are the most effective ways to do that? And then I think, what types of messaging are going to resonate with that person as an elected person? Maybe Teresa, I'll start with you.
Okay, so I already told you, go to Sheena. No, they're on my own. I guess it all starts for me with relationships and connections, and like what I said in the last bar was find a connection to say a bencher, and I encourage you through the practice area. I said find something that draws you to another person that you can sort of open the door and go through to build that connection. Don't be afraid. Don't say, oh, it's the treasurer, or oh, it's a bencher. Don't be afraid to make the connection. So for me, when I was the treasurer, I ran it like I ran my practice. As a Crown, I had an open door. I would meet with anybody. If somebody came in off the street, I would meet with them unrepresented. They had concerns. I met with everybody because I thought that I was the Crown attorney in a small town in Goderich, 80,000 people, my county, 60,000 people. It just made me understand better what was going on. And I continued that. What I didn't put on this slide presentation was my email address. Everyone I ever did as a treasurer, I said, here's my email address. Call me, contact me, reach out to me because I want to hear you. So you need someone who's in the role of the treasurer who wants to hear from you, and that's the treasurer's job. So if the treasurer got the job as the treasurer, part of their job is to build these connections through stakeholders and listening and having roundtables. So that's why you're there. So use that to build the connection and to have the outreach. And as for the second part of the question about the messages, know who we are and know what our job is. So, as my role as the treasurer, I can't get involved in individual discipline cases. I'm not, my job isn't to make sure that the court reporter and the court staff who are showing up for work on their jobs, understand what our role as a legal regulator is and what's within our control, because then the messages resonate much more strongly than an issue that's not ours. Okay, someone else, go talk to the Attorney General, go do something else. And not in a buck-passing way, but in a way that we can't help you. But if somebody continually comes to you and is asking you something that's not your job, I think that's you're going to kind of, I don't want to say lose interest, but that's not going to be your priority anymore. You'll be working with somebody who does help. So over to you, Michael.
And I think, just before we move on too, my impression of many of the people who've been elected and people who've previously been on convocation too is that they're real people, much like the people in this room. I think you've given us great context for a lot of their professional background and their stories. And despite all the buzz, they're not all out of Touch Bay Street lawyers and elitists. There are a lot of sole practitioners, people doing a lot of, I think the same types of work at legal clinics and other things. So connections, I think, are huge. I mean, I know we've connected a lot about municipal political shenanigans. That's a big part of repartee. So there's always something like that.
It's true. It's true. You just have to find the connection.
Yeah. Go ahead, Mike.
So I guess the difficult part with moving or motivating a decision maker, attorney general, deputy attorney general, depending on what you're trying to change, getting staff attention is that justice policy isn't a huge vote mover most of the time. It's not a ballot issue. And that cuts both ways. So one thing that means is most of the time the Premier's office and other sort of political decision makers that are in and around the government will stay out of your way because they don't care, and if they don't hear about it, it's good. And so you get some leeway to do what you want to do. The downside is when you want to agitate for change, it's a bit harder than it might be if it's, healthcare system in crisis or things like that. So it really does turn to knowing who to call and knowing how to get your agenda item or your issue into the attention of the decision maker. Teresa's point, knowing what the issue is, if it's court staff not showing up at some remote location, That's not really a thing that the Attorney General needs to deal with himself. Like that's in theory, an administrative matter for the Court Services Division. So if it's really becoming a problem, you might need to get some attention to it, but it should be easily corrected. Whereas if you need some sort of big legislative reform or regulatory reform, that's obviously more effort and does need the Attorney General's attention and sign off. But there's like a lot of ways into sort of getting your issue on, you know, if you don't know who to pick up the phone and call in his office, there's lots of people who do, whether it's Katie or Sheena or whoever in these organizations, in the legal community, local members of provincial parliament. There's only 120 members of the legislature. They're together 3 weeks a month. And it's easy, no matter what side of the legislature they're on, to get up and walk across the aisle or walk down the aisle and say to the Attorney General, oh, I'm really having an issue with this. Here's a letter. Can you have your staff look at it? And so members of provincial parliament can be effective in getting issues on the agenda. If it's a local issue, the parliamentary assistant, the minister's staff, senior civil servants, and sort of the staff leadership within the legal community organizations, LSO and COBA.
One question for you within the AG's office. I think, whether it's the AG or a different minister, I know there's other ministries that touch on our work, and certainly at the federal level, there's portfolios as well. You go to the federal directory or the provincial government directory, and you put it in the office, and you get this list of like 1 million people. How do I sort through and figure out who it is I actually want to talk to if I'm not going directly to the boss?
Yeah, I mean, that's a hard question. So if you look at the list and you don't know anyone, then you're sort of lost. But there are people in these organizations, like Katie could tell you who to call, Sheena could tell you who to call, people like, and they have the ability to, you know, they can't make every issue their issue, so don't always call Sheena. There's the opposite advice. Like, but you know, there's people in the community that can give you guidance as to who it is that's going to carry an issue. And the real question you're asking is, you know, the minister may have 3 or 4 policy advisors. Which policy advisor would have this file? That's the question you're trying to ask. Is like, you know, if these 4 or 5, you know, I don't need to call the office manager and I don't need to call the driver. If which of these 4 or 5 policy advisors has carriage for the Court Services Division file? And that's the question you need to ask, and it changes. There's lots of turnover in these jobs, so it changes all the time. And there's reassignments of different file responsibilities, but that's the question you're trying to ask. And usually somebody in these organizations will be in the know. And so ask Katie, ask Sheena, ask me, ask whoever.
Thank you for that. We talked a little bit about how, and I think Teresa, you said, know the role of who you're talking about. What's their job? What are their parameters? How much of the engagement we make with these people in these jobs should be solution oriented? I'm wondering if either of you have thoughts on that. Like, is that more helpful? Because I think sometimes we don't necessarily know all the solutions, but we know there's a problem.
Obviously, coming in with a solution and one that's workable is way better than not. The other thing is from the perspective of the person sitting on the other side of the table, like you do a lot of stakeholder meetings. You sometimes go a day where you'll just go meeting back to back to back, whether it's a briefing or a stakeholder meeting on any range of issues, building a courthouse, cannabis regulation, legal aid funding, whatever. You'll go through a series of briefings and a series of stakeholder meetings. And so offering a solution, offering a pitch, it's almost like a pitch on like Dragon's Den on one of those shows. Like you need to have something that sticks in the person's mind, because you know you're with them for 30 minutes or 45 minutes or an hour, and they're going to walk out of the room and go into a very next meeting, and it's for them to remember what you asked at the end of the day or whenever they finally get a chance to deal with it. You're stacked up against a bunch of other asks. So going in with a solution is always helpful in that regard, because then it's easy to just say, we should just do this, or is this, you know, asking somebody, is this feasible? Can we do this? I guess the other thing I should say too, maybe this is back to the last question, is I would just try to go in yourself. Like, it is better if it's a local law association going to the local MPP, or FOLA going to the minister, like trying to amass support within the organization, because again, from the stakeholder perspective, I can't do 42 meetings on the fact that court services staff show up late, but I can do one meeting with FOLA on the fact that court services meeting shows up late. So even though justice policy as a whole is an election issue or a vote mover, when you're dealing with sort of, like, think of it as the 3 big stakeholders in the legal community in Ontario, if it's FOLA showing up and saying this is a problem, it gets more attention than an individual lawyer from Oshawa showing up and saying it's a problem, or the Durham County Law Association showing up and saying it's a problem. It's better to show up in mass with the whole group having thought about what is a workable answer, accepting that it's not always obvious what's workable.
Yeah, that's, I think that's helpful, and, you know, you've sort of, I think you touched on something that often there's like a list of these meetings. Call them auditions, like American Idol. You want yours to be memorable for the right reasons, like American Idol. So no, I think that is helpful advice. Teresa, maybe I'll start with you for the next question we had, and I'm moving down the list because you've covered so many things we were going to talk about already, but I wanted to ask, and this is also your like 10-minute warnings, the mics are open and we will take questions, so think about what those might be. But the next question was, you know, when should stakeholders think about changing their approach? Like, I'm assuming you both probably been in this role where you hear from the same group or maybe similar groups sort of singing from the same song sheet over and over and over again, but it doesn't align with the strategic direction. There's a fatal flaw that just doesn't fit. When should you take the message to move on or change the pitch? I'm wondering if you have thoughts on that.
I would be inclined to tell you it's not working. Like, move on. And, you know, that there's an issue with it so that you know to move on. I mean, I think if you're in the position where you're trying to influence decision makers, you have to have some emotional intelligence and some, you know, you have to be able to read the room and read what they're saying to you. It's not going to be like what Mike said in the beginning about, you know, you don't go out and just attack the legislation. You know, if you're going to do the performance evaluation, you sort of do it in a good way. But I think you have to understand what they're saying to you. It might not come right out and say it's not working, but if you're repeatedly doing the same thing and it's not making a difference, I think you got to try a different strategy. And if I could just pick up on that from what Michael said about, he essentially in his last answer gave us two really important things. One of them was build local connections, so the one-on-one connections with the MP or the MPP. But the second was the whole stronger together piece that I said. And the third thing he said was make whatever you're doing compelling. So to go back to your question, Doug, if it's not working, I think you got to retune it and figure out how do you make it compelling? How do you, and maybe it's the same, maybe you're hoping to get to the same place, but maybe there's a different path that's going to open up the decision maker's eyes to say, now that you put it that way, and I see it through that lens, that completely changes how I think we're going to end up, or how that completely changes me. So I think don't keep doing the same thing, but I think different strategies to try to get to where you want to go. And if it's really important, don't give up.
Yeah, I think that's right. I also think it's hard to say like when, like in terms of offering a time, because you know you might push at something for 6 months, a year, or more, and it doesn't get done. Not because the person doesn't want to do it, but just it isn't gotten to the top of the list for whatever reason. And that's not usually anything to do with your organization or your ask, but all the other pressures that are on dealing with whatever else has to be dealt with. I mean, obviously there's some policy asks and decisions that you get to a decision point and you can see the government takes a decision that goes one way that's not the other. So, you know, we determine whether you have to wait till the next government or whatever the case might be. And you do see that where people wait, people try one thing with one minister and the minister gets shuffled and the next minister shows up and they try again. So there's always like resets in government and reset in agenda, so there's opportunities. But yeah, if you think it's a good idea and it's just not getting traction, and you're getting sort of favorable noises from the government but they're not doing it, it's probably sort of retuning how your approach is working or getting more people aligned in the ask. Obviously, if somebody shows up and says, we have this solution to a problem, there's no cost, and every stakeholder's aligned, okay, the government will do it. Typically, there's either a cost or there's stakeholder disunity, and so it's if you can deal with one of those two issues, then maybe that's the speed bump in getting it moved forward.
No, that is helpful, and I think Teresa talked about this in her presentation earlier about sort of the codified strategic planning process of the Law Society. Mike, I'm wondering, sort of jumping off of some comments you made about the cycle. So we're now we're coming into a year of the current government's term, the provincial government, what considerations should stakeholder groups have in mind when they're engaging with government, over that sort of, that term? When should you get on the elevator?
For the pitch? I mean, now's good, right? Like, it's a 3-year window. That's a lot of time. You can do essentially anything in 3 years, 2 years. Governments start being less able to take on new initiatives and make meaningful change in sort of the last year, 18 months. Again, if there's complete agreement in the stakeholder community and there's limited cost, then you can do anything anytime. But no, now is a perfect window to get in and get things done. It's also a second-term government, so if they had views of what they wanted to do at the outset, they're probably running low on the list, like the to-do list. Like, they're much more in management role than in change role. So easier, governments are looking for things to do. The other thing is this government in particular uses omnibus legislation very frequently, where they, a budget bill will have all kinds of different legislative reforms in it, and they'll usually do a red tape bill once or twice a year, which are just sort of grab bags of legislation. And if you can dress up what you're asking for as red tape reduction or somehow business-minded or whatever, and even, every law firm is a small business, or a large business, but mostly a small business. So, if it can be dressed up as red tape reduction and things like that, then there's ways to sort of get things on the agenda in that cycle of red tape reduction or budget legislation.
Thanks for that. My next question I'll put to both of you. You might have different perspectives on it. Some of our challenges, such as on legal aid, cut across federal and provincial. The federal lawmakers, I think, and federal policymakers have a broader range of stakeholders. They're dealing with people with their feet in different jurisdictions. It's necessarily more complex. So I'm wondering if either of you have advice for how stakeholders can engage in effective advocacy at the federal level on these types of
issues. The model's not that different, right? The minister, attorney general, deputy attorney general, minister, deputy minister, political staff, public servants. So you sort of have the four corners at both levels. You're right, they have different issues and a broader stakeholder range. It's the same model, though. Like, if you can get your local MP involved or engaged in what you're doing, and he or she can go talk to the minister, deputy minister. It is a bit different federally. Like, there are, it's 3 times the size, so there are actually ministers that don't know MPs. Whereas in Ontario, every MPP knows every other MPP. It's just a small enough club that's the way it works. In Ottawa, there are ministers that don't know opposition MPs and don't even know backbench MPs in their own party. So it's not quite as effective to go to your local MP to try to move the federal dial. The provincial governments, have an opportunity regularly at federal, provincial, territorial meetings to put items on the agenda. So if you can get provinces, one or more provinces aligned or interested in an issue, it can sort of get onto that agenda, although that again is hard because justice policy is not a huge vote mover, but it's usually the things that are the most high profile, right? So we're seeing bail reform. A few years ago it was legal aid funding, now it's bail reform. Like, you see really only the top issues float to the agenda, but you can get, the provincial ministers can get the federal ministers' attention. Again, stronger together. Good keyword here. It's true for the provincial attorney generals as well, attorneys general as well.
Thank you.
Can I ask a question?
Sure.
What about an organization like FOLA using a lobbyist? Like, I'm thinking federal government, legal aid, like a really important issue that crosses all the law associations, FOLA, and so many people in the province, and so important for access to justice. And how do we motivate both levels? And is a lobbyist something that makes sense for FOLA to do, or that doesn't make sense? Sorry about that, dropping that on you.
No, that's fine. It's a good question. I think it depends on the issue. Like,
Legal aid.
Probably, maybe federally, probably not provincially. Like, the 3. So I guess we're going to get a whole conversation about lobbying now. I think the 3 legal organizations in Ontario, the three main legal organizations in Ontario, the Law Society, the Bar Association, and FOLA.
I appreciate you saying that.
I mean, it's my view, is do not need a lobbyist. Katie or Sheena or Betsy can pick up the phone and call the Chief of Staff of the Attorney General any day of the week and get their phone call returned and get an answer or get a meeting or have a discussion. That's just a legacy they've built over the years. Now we can't talk anymore.
Yeah. Look at that buzz.
Get out of this room. Yeah, this is a closed session. This is a closed session. I don't think that the law associations in Ontario need a lobbyist, certainly to open the door. What they may need is help, and public affairs firms, lobbying firms, the good ones are better at this. In fact, good lobbyists don't even usually make the call for you. They'll help you formulate the ask, right? So you don't necessarily need a lobbyist to get a meeting or to get a call returned, but they can help you understand what the decision makers are thinking, what the other pressures are. You know, when you say, why isn't this issue happening? The lobbyist might be plugged in enough to know, well, you know, the reason that issue is not happening is because that minister's in a fight with this minister, and so you're never going to get it done that way, and that can help you recalibrate your ask, your approach, your message. But you don't necessarily, so if it's a big issue, or it's an issue that you're having trouble getting traction on, maybe yes. Day-to-day stuff, you guys have day-to-day stuff between the three organizations and the minister's office. The relationship is so long-standing and so strong, I don't think you need.
It sounds like you're describing the lobbyists you have to think of them as another professional advisor that you would use. That's gonna give you, I'll call it the palace intrigue of what's going on.
Palace intrigue and help sounding board, same thing the chief of staff would do for a minister. Sounding board as to, is that really gonna land with this government or with that opposition member or with that minister? That's what a good lobbyist can help you do. Literally anyone can get a meeting with someone.
I think we're almost at our time for this, but I want to stop asking questions, and I wanted to invite anyone here wanted to come up to one of the mics and put anything to Mike or Teresa before we end this session. Katie, I'm just checking our time. Are we 12:20? Okay, so if there are any questions or comments, here he comes. Oh, this is going to be good.
The courthouse in North Bay has a broken.
That's right. I'm Gord from the Nipissing Law Association, and I know both Mike and Teresa. And so James works in Burlington. He's a personal injury lawyer. I practice real estate. I've heard this legal aid stuff forever at FOLA, the FOLA plenary. And, so listening to what Michael has to say about the ballot box question, I've always said, and I want to hear your opinion on this, why don't we make legal aid a ballot box question for the government? So they have to respond. When teachers get in, when they want to get paid more, they go on strike. When nurses want to get paid more, they go on strike. And guess what? Parents hate kids out of school. Nurses, parents, and families hate when they can't be taken care of at hospitals. So why can't forget about a lobbyist. Why can't the lawyers in Ontario, go on strike and say, we are not taking legal aid certificates? Would that not become a ballot box question when these people, marginalized people, and I get it, there's not a lot of sympathy for lawyers out there because $110 an hour, while we complain about, or you guys complain about it, to the regular Joe, $110 an hour is a lot of money. They don't get that we have to pay overhead and pay staff. So how do you frame that as a ballot box question for legal aid? Do you go on strike? And so anyway, James and I, the personal injury lawyer and the real estate lawyer, want answers.
I mean, there was a legal aid strike before my time. There was a legal aid strike 20 years ago. I don't know when.
Legal aid lawyer when the first legal aid strike happened. I was a fairly new panel lawyer. I was pulled in 2000. I think the legal aid strike was 2002 or 2003. And the problem was that each law association decided what they were going to do. So there was no sort of generic mandate that everyone would stop taking the certificates. So the Norfolk Law Association had a resolution that we would just stop taking certificates. The only exception we made was for mental health clients. And so but other law associations, I know there's a larger urban law association near us, and their resolution was that, and we also stopped doing duty counsel. Another larger law association near us, their resolution was that they would no longer provide duty counsel services on Thursdays. And so what did the court do? Well, the court in that jurisdiction moved the criminal courts to other days. And in our Norfolk Law Association, Legal Aid's response was we were the first county that had a full-time staff duty counsel person appointed. And we're a very small county. So the strike was I think it had some impact, but on the other hand, it was a mixed response across the province. The other thing that we had happening was we started seeing out-of-town counsel appearing in our area on legal aid certificates. So the word got out that they weren't accepting legal aid certificates in our area, and people from outside came and picked it up. But because there was no unity, no solidarity, unlike the nurses and teachers and other people who do the same thing together, or if they do regional action, they agree on what that's going to be. We had a varied response all over the province in terms of the legal aid strike. So I think that's why overall it wasn't. I think it got some results, but it wasn't a very effective method. And the main consequence of it was that it accelerated the move on legal aid's end to have more clinics and fewer certificates.
So we're moving from the making friends to influencing people. theme of the panel.
Well, the question, could a strike move friends and influence people? Or make friends and influence people? I don't know if it can make friends, but it might influence people.
Yeah. So I don't see anyone else up at the mic, and I did see the attorney. Oh.
For Teresa, Bill Woodward, former chair, Middlesex County. We appreciate the various committees that the Law Society has. Other than calling Sheena, is there some process to, if, for instance, audit and finance is always a concern for this group, is there some way to get in front of audit and finance to make some form of submissions, or is that really an informal thing?
Didn't you come to audit and finance when I was the treasurer?
I did, because I didn't call Sheena, I called you.
Yeah.
Okay,
so
we
Bill
had
and I
that-
have known each other
we
for
had
30
that connection, but
we-
not
we've-
everybody in this room does.
It's not a secret, but I did article at Bill's firm. So, so that was a wonderful connection. Is there a formal way? No. I think you would reach out to the committee chair, and the committee chair ultimately would make decisions about who can come. And I'd have to get bylaw 3 out to look at bylaw 3, but I'm pretty sure it says that the committee chair can invite non-committee members to the meeting, or the treasurer could. So I think it's important that we hear from you. I'm not the treasurer anymore, so I can say this. I think we do have work to do at the Law Society to be better at gathering input at certain stages of what we're doing. So I think while we have this really great relationship overall, there are things that we're doing that we could be better at communicating out what we're doing. And I think that direction has to come from the treasurer, sort of looking at, are there ways, can we make committee agendas public so that you know what we're working on? When I was the treasurer, I did a letter to each of the committee chairs, and I said, here are the things that I want you to focus on. Could something like that be made public as a direction from the treasurer to say what we're working on? Because we post our convocation, sometimes we post our convocation materials, like if it's like the technology sandbox, we're 2 weeks, 3 weeks, or a month family legal service provider, we do it ahead of time. But generally, you get like, what, 3 days notice before convocation? And that's tough. And it's tough for everybody when you're first seeing what we're dealing with. It's tough when you have an executive with people in different law associations across the province to try to get a unified voice, and we know that. So I think there are ways in which we can be better. I encourage you to keep the pressure on and think, what are the ways that could make it more transparent, and then connect. And I say that as the former treasurer, who's not going to get that letter. But I really do encourage you. I think we can be better at it, and I think we should be better at it.
And maybe something to add to your strategic planning discussion.
Yeah, maybe. Yep.
Thanks, Bill. So we are just about at 12:30, which is our lunch break. I did see that the Attorney General snuck into the back. He's run to hide now, I think, because he saw what we were talking about.
Just I'll remind him about my disclaimer.
And mine.
And that I said nothing about a legal aid strike. Let's all remember
They
that.
were on their best behavior,
Yes.
right? Yeah, Scout's honor. Okay, so I think we can wrap up. I don't see anyone else at the mics, but I'm sure Mike and Teresa will be here for a few minutes if people have any further questions or follow-ups, any localized issues. But I wanted to thank you both for sharing your time with us and your wisdom, and we really appreciate your friendship of FOLA, and we hope that you'll continue to be part of our events like Plenary.
So I just want to finish by saying I'm a huge advocate of FOLA, and I'm a huge advocate of the local law associations. So I told you I have an open door policy. I mean that seriously. Feel free to call me, reach out to me by email. My email's on the Law Society portal or website. Reach out to me. I'm happy to chat if you have questions about convocation or strategies or the Law Society or really anything else related to law. Thanks. And he said the same too, because he's got the AG.
Really, that's really Teresa.